Are you on both sessions or on both sessions?
Both, yeah, just overall.
Well, I've learned many things today. I don't need this. And the fact is I've only read the first version of the draft. I haven't read the second version of the draft, so I understand there's some discussion about paragraph 16, but I haven't seen it. I was very interested by what Professor Lagutin meant. Now, obviously, we cannot dissociate competition law and competition economics. That will be bringing us back to the old 50s and the hardest ordo-liberal approach that we had then. But if my understanding is good, there's still some discussion about how the base of the amount of fine should be defined. And I have the feeling that Article 6 in the version that I've read is about, it isn't clear in my mind whether it's about sales or whether it is about benefits. And I have the feeling sometimes that what was trying to be achieved was to get an economic analysis of the fine, a fine that will be economically sound. Oh, well, obviously it's a very good goal, but I think the real aspects for economics is whether there has been an infringement. We need economics to ascertain a vertical restraint. We need economics to refuse, accept a merger to measure efficiency gains. When it comes to deciding once an infringement has been determined, what is the right penalty? What should be the amount of the fines? I think it can only be used via proxies. Well, if it's an heavy infringement, and if this company's turnover is that amount, then we should be in that category. Trying to tune the fines to the economic advantage is, well, in my opinion, is quite difficult, hardly even possible. And it will end up to discussions about what has been the exact advantages or disadvantages, and I don't think it's really workable. I think there's the right place of using the economics in determining whether there is an infringement. When it comes to fines, then obviously it's more a question of proxies, of categorizing things. But maybe I haven't understood things properly, as we said. Now, moving on, the question of the briefly on the second session, which is access to information and making things as public as possible. Well, what has been said in relation to the practice in the United States is to a large extent also what we have in the European Union. I wouldn't go as far as to say that most decisions can be made public without modification. It is frequent in antitrust cases, in merger cases, that the public version is somehow black penned compared to the actual version. But it doesn't make any real difficulties because the information that are blackened are usually about the company's turnover or information about people who have been given the first information in the leniency proceedings. The legal aspects and are usually open to everyone. Now, the difficulty that we have, especially in the European Union, and I suspect it's something that will happen in the future in Ukraine as well, is confronting access to information and protection of leniency applicants. I mean, in cartel cases, a large portion of the information is coming from companies who are deciding to betray their brothers, if I may say so, in the sense that they know that they've been indulging into something which is not very nice, but if there's a first in the rat race, then they would get 100%. Obviously, for the companies, it will be a real problem is that if access to information means that they won't get any fine, but they might be subject to huge damage claim in front of a national court. So there's a real discussion because the Commission has long tried to refuse to provide any information about leniency applicants, about information that are being provided with leniency applicants, because it wants to protect its leniency program. The General Court has disagreed in the past with the Commission and said you cannot just put forward the magic name of leniency application and refuse to provide documents. And you have to do on a case-by-case basis, and you have to really confront argument. Now, there's a new regulation coming, and basically it is trying to balance those conflicting interests, but that will deserve a topic of its own. The last thing I can say, and I want to be very brief, is we also have a lot of issues about protecting confidential information in the course of investigatory measures. When the Commission is having done raids in companies, or when it's asking for information, we have challenges against those decisions. Undertakings come in front of us and basically want us to annul a decision, an inspection decision, and usually they're asking to get access to information which the Commission is not yet forced to develop, and there has to be here as well kind of a balancing exercise. That basically what I wanted to say. Thank you.
Thank you very much. Hassan.
Thank you very much. One point I would like to add to what was said earlier about the setting up of fines is the need to emphasize proportionality. I think it's a guiding principle that regardless of the details that we discussed earlier about the discussion, to maintain the principle of proportionality and effectiveness in setting up the exercise. But also to emphasize that sanctions and decisions are taken by the anti-monopoly will be complemented through judicial review, that the parties will have possibility to appeal these decisions, which in turn, of course, depend on whether the courts are functioning well and whether the judiciary will be cooperating in this system. And I think this is something that perhaps also it's important to emphasize in our discussion. On the question of transparency, I keep on hearing an echo behind me.
You need to take them off.
That the antitrust analysis is becoming extremely complex, both in use of both legal and economic tools. And this complexity would require more and more transparency on the part of the agencies, because the more complex the tools, the more difficult it is for the party to know which analysis is being used and how decisions are being reached. So that itself would require more transparency in general, including in the cases of setting up guidelines and reaching decision on the appropriate and proportional fines for a particular case. Now the question is, how much transparency? I think transparency, it's good, it's very important, but it also brings costs, and it goes at the cost of inflexibility or lack of flexibility on the parts of the agencies, and it might actually lead to questioning of the legitimacy of the agencies, because the more the media and other parties question this decision publicly, the more it undermines the legal basis on which the agency work out. So there are costs. So the implication for that is that you need that the optimum level of transparency will require some balancing act between how much openness and how much will be made, of course, respecting the need for legal certainty. Legal certainty is required for enforcing the law. My conclusion from that is I think it will be important, particularly for young agency, to emphasize transparency in the process of reaching decisions and less on details. Because the more details are, the less complicated and less open for discussion and issues. Now, what does this mean is that maybe in the process, if during the process, after these recommendations are out and it's emerged that there are areas where there is more need for transparency in that particular area, then the Anti-Monopoly Committee can provide more information and come about more clarification on that particular area, rather than go for a total transparency. The second, related to this issue, is that like all agencies, and some of the lessons that you could see, is that for agency to be effective, you need to continuously evaluate what are you doing, how are you doing it, this is the most effective way, and to revise this process. So if you're doing that, I think it also allows you need this flexibility for you to continually question yourself, whether internal evaluation or external evaluation, whether what you're doing is the right way. Are you moving with the market? Are you responding to the need for the work? And then the other way you can also remedy this lack of not 100% or transparency in the details is that you will need to publish decisions. And the motivation of decisions would be another way to provide more transparency as you go along in the process. And last but not least, as I said, that the parties still have a route for judicial review, which can be another way to provide check and balances in the process. Thank you.
Thank you very much, Hassan. Russ, do you have any additional comments as closing remarks? Piotr?
Thank you very much. I have just two short comments. First, about fines. I would say that we should meet in 6 months, or even better in 12 months, and talk about how does it work in practice, because it's the most important, actually. And the second thought I had about the making decision public. Within my system in Poland, we have the internal obligation to make public a decision within 3 days after delivery to the company. And it is very often that companies don't inform the office exactly what they think is a confidential information. And of course, the public version should not include any business secret or any personal data. And it's actually on the office, it's the office responsibility to avoid revealing such an information. So it's very difficult for us, and we need to take care each time we're issuing a decision, and we make it public later on to check whether it doesn't include any secret information. Thank you very much.
Thank you very much.
Thank you. Just to say, I'm really sorry that my colleagues from DG Competition could not be here today. They really wanted to, but it just clashed with other things in their calendars. I think we've obviously shared the paper with them, and I think we welcome this event, and we welcome the paper. We provided some comments. I hope some of those have been useful. But I think we certainly see this as a step in the right direction. It's progress. Because I thought, there's been lots of discussion here, and I'm not a competition expert, so I'm not following it at all, but I see this is a document that will help in transparency and certainty, and that's what we're trying to achieve. Thank you for the second draft. This is at the moment still in Ukrainian, so I have not time to digest that, but hopefully there will be an English version at some stage, and we can see what comments, and also be happy to, before you publish, and I know your timetable is very, very tight, happy to feedback any comments from my competition colleagues before publication, if that's possible. Thank you.
Thank you very much. Юрій Олександрович, чи є якісь остаточні?
No, yes, I'm very grateful for the comments of all the international guests and of the all the participants of this round table. It has been a lot said about penalties, about the way penalties are calculated. So basically, this topic there has been too much said on it, and I think now a lot needs to be done. Yeah. Still to make a document, if not perfect, but operating in the best way. Talking about transparency, basically everything which you have said is resonating well with our internal vision of this priority. What we are looking at transparency. Transparency can be looked at from two sides. Yeah, it's substantive, transparency, and formal transparency. So I think the formal element of transparency with regard to all the legal and regulatory limitations about publication of decisions. All these issues can be sorted out, can be resolved, and it is a matter of either establishing a process or clarifying some restrictions or limitations with other regulatory bodies in order to get clarity about what scope of information can be viewed as confidential, classified, things like that. But I think a bigger topic is substantive transparency. It's about how decisions are actually being made in the authority, and that the way they are made is transparent and is basically continuous and systematic. So in this regard, we are, I think that our intention to publish and to really regulate the way we determine penalties is the first step, but it should be cascaded, this whole approach should be cascaded down to all elements of our work, and at some point of time we will have something similar, maybe where possible, to like operating procedures for every particular maybe action, so that things like I don't know, unfair competition violation or decisions on specific maybe market assessment issues, they should be done on the basis of a very concrete algorithm in a consistent, similar, repeated way. And we would very much welcome maybe external assistance from you or maybe from Ukrainian lawyers with regard to determining these algorithm or checklists or procedures, how to assess every particular situation comprehensively and appropriately. So again, our transparency is really the priority of our Anti-Monopoly Committee, and we are committed to it. So, thank you very much.
Дуже дякую. На завершення я би хотів подякувати всім присутнім експертам. Також я хочу подякувати нашій онлайн-аудиторії. Ми отримали ряд запитань.
We don't have any more time, and we have misused already our time, and all the questions will be published on the anti-monopoly website, and we'll have on our website. I just wanted to thank online audience for all the questions and for very active participation in the discussion, and a few words about recommendations as a result of this event within a couple of days. Until Tuesday, our fund will draft the first version of recommendations, including the comments of the experts present here, and as well for the future edition, for the future version. And this version is going to be published pretty soon. So the way usually we do it, we invite all the experts to discuss all the recommendations, and we'll finalize the text for publishing it, resolutions and recommendations. And I just wanted to thank you very much, Anti-Monopoly Committee, thank you very much to all the experts, and for sure our international experts. They spent a lot of time, arrived here, prepared to do this presentation, and they were very much topical and to the point. Thank you very much. I just wanted to thank on behalf of all our audience them, and expecting your new proposals and recommendations, and see you next time. See you next